Anthony Stewart, Michael Stewart, you can remain seated for the moment. Anthony Littler was, in 1984, aged 46 years. He was, according to those who knew him, a quiet, kind and gentle man. He lived a quiet, decent and honest life. He worked as a civil servant and lived alone in East Finchley. He was a real ale enthusiast, and on the evening of the 30th of April 1984 had been, after work, to a meeting of a society formed for the preservation of real ale. He travelled home by public transport, and when alighting from the tube not long after midnight, started to walk home along an alley which then led from the tube station to East End Road, as no doubt he had done many times before. He did not even make it to East End Road. He was set upon, I am satisfied, by a group of boys or young men and hit with an implement, most likely a baseball bat or something akin to it, to his head with such force that it fractured not only the top of his skull, but also the bone underlying his brain. He would have lost consciousness immediately, and he died within a very short time. You, Anthony Stewart, and you, Michael Stewart, were part of that group. You were aged 18 and 15 years respectively at that time. In terms of your roles, neither of you gave evidence at your trial. It was the prosecution case that you, Michael Stewart, acted as lookout at the end of the alley. I am satisfied on the evidence that I heard that this was your role, not least because you let that slip during the course of your interviews with the police. Anthony Stewart, I have carefully considered the evidence concerning your role. I am satisfied that there were more than the two of you involved in this killing. You, Michael Stewart, have said so in the ensuing years. In addition, Mr. Littler was hit twice to his head, once with the bat-like implement, and also to the side of his head with what the pathologist described as a lighter weapon. This indicates, in my view, that there were two people, each with a different implement, at the time that he was hit. The prosecution assert that the evidence shows that you, Anthony Stewart, were the person who struck the fatal blow. Whilst I think that is likely, I cannot be sure to the criminal standard that that was the case. I recognise that Michael Stewart told your younger brother Daniel at the time that that was what happened, but he has said many things over the years, and I don't find that sufficiently reliable to make me sure of your role. The confession you later made to Daniel was insufficiently detailed for me to conclude that you struck the fatal blow. I sentence you, therefore, on the basis that you were a secondary party to the killing of Anthony Littler. The role of each of you was nonetheless significant. This was no impulsive attack. I am quite sure that your group was lying in wait in and around the alley for a victim, someone to attack and to rob. I am sure of this for two principal reasons. First, this is what I am satisfied you were in the habit of doing. I heard evidence in the course of the trial from your sister Gaynor and your brother Daniel that you both would often speak of going out to hurt and to rob people. I emphasise the word "and." You were not planning to rob just anyone. You were targeting a group in particular, and that was homosexual men. 1984 was a different time, and in many respects a different place. Then, opportunities for homosexual men to meet were fewer than today. They would often do so in and around public conveniences. However, those taking part in such locations in sexual homosexual acts were committing an offence. That made this group vulnerable, because they were highly unlikely to report it if they were robbed. That is what I find you were doing, but I also find that violence, not merely the threat of it, was intended when you confronted those you believed to be gay men. You were not just threatening them with violence, you were perpetrating it. Gaynor Stewart spoke of you speaking about, in her words, hurting people. Daniel spoke of your primary purpose being robbery, but you would, in his words, bash people first and then take their money. He spoke of the two of you boasting about going into toilets, whereupon you, Anthony Stewart, would go up behind people and literally push their heads into the water down the toilet. I am therefore satisfied that part of your motivation in targeting homosexual men was hostility towards them. There is no evidence that Mr. Littler was homosexual, but he was a lone man in an area you frequented to target homosexual men, and I have no doubt that he was targeted for that reason. Second, I am satisfied that there was planning, and your group was lying in wait with at least one weapon for a victim, on the evidence of Mr. Dyer, who was walking his dog close to the scene of the murder as it happened. He did not hear any demand for money. The first he heard was a loud cry of pain from a man, and that must have been when Mr. Littler was struck. He was therefore struck before any threat of violence was made, and this shows, in my view, that your group intended the violence before any robbery was to take place. That said, the prosecution rightly do not assert that you had an intention to kill Mr. Littler. Rather, your group went armed to find and hurt an individual before robbing him. The hard blow to the head indicates, as the jury found, that your group intended really serious bodily injury. Mr. Littler was the unfortunate victim of your plan. As I have said, there was nothing in his life to suggest that he was homosexual, but he was a lone man in that quiet place, walking towards East End Road, where some public conveniences were then located. You targeted that decent, honest individual, and you took his life. I am to sentence you for that murder today. Those that knew Anthony Littler were deeply affected by his loss. He was not part of a large family. He was his parents' only son, and he was devoted to his mother. His cousin, Patricia McClure, speaks of a kind and loving man who wrote every week to his mother without fail and who took his holiday with his parents every year. It was a great sadness to Mr. Littler's mother that she died without ever knowing what happened to him. He was like a big brother to his cousin who was devastated by his murder. He was a loving godfather to her daughter. His work colleagues spoke at his funeral of how lovely he was and how much respect they had for him. For over 42 years, none of Mr. Littler's family knew what had happened to him. Their grief was made all the worse for the fact that those who killed him had not been brought to justice. I recognise how difficult that must have been, and that any sentence I pass today can never recompense those who loved him for their loss. I have said that the world in 1984 was a different place. People did not habitually carry mobile telephones. There was no CCTV, and identification through DNA was in its infancy. The subsequent police investigation failed to identify any suspect. In the meantime, having taken Mr. Littler's life away from him, you continue to live your own. It was not until 2013 that what had happened started to emerge. I pay tribute to the courage of Daniel Stewart and a lady I propose to refer to as AB, a lady with whom you, Michael Stewart, were in a relationship for a time, for their courage in coming forward initially to the police and for giving evidence in the trial. Michael Stewart, you had confessed of your and your brother's involvement in the murder shortly after it happened to your younger brother Daniel. True to form, as it was to be characteristic of how you spoke of it subsequently, you were boasting to him about it. At that time, you were aged 15 years and he was only 10. He was frightened of you and did not tell anyone what had been said. You later, in 2012, boasted of the murder to AB, astonishingly thinking that that would impress her. You, Anthony Stewart, seemed more contrite, at least at the time that you admitted to Daniel that you had been involved in the murder. When he asked you about it, you were tearful when you accepted you were involved in killing Mr. Littler, and you can be said to have been, at least at that time, burdened by guilt. But in spite of these confessions, you both contested your trial, and whilst that does not increase your sentences, it shows nothing of remorse. Anthony Stewart, for this grave offence of murder, there is only one sentence prescribed by law, and that is imprisonment for life. In your case, Michael Stewart, it is detention at His Majesty's pleasure by reason of your age at the time of the offence. That is the sentence I shall impose upon each of you in due course. However, I am required to determine the minimum period each of you should serve in prison before you are eligible to be considered for release on parole. The minimum term is not a fixed term after which you will be automatically released, but the minimum time that you will spend in custody before your case can be considered by the parole board, and it will be for the parole board to say at that time whether or not you will be released. If they say you should not, you will remain in custody. If and when you are released, you will be subject to licence, and this will be the case for the rest of your lives. If for any reason your licence were to be revoked, you would be recalled to prison to serve your life sentence in custody. As I have said, this murder occurred in 1984. If I was sentencing you for a murder which happened in more recent times, I would do so by application of Schedule 21 of the Sentencing Act 2020. However, in 1984, the minimum term was not set by a judge, but by the Secretary of State, following a recommendation by the sentencing judge. The law requires me still to consider what sentence I would have imposed upon you at the age you were when you committed the murder by application of Schedule 21. But paragraph 12 of that schedule then requires me to set a minimum term no greater than the period that would have been imposed by the Secretary of State before Schedule 21 came into force. That is going to make a significant difference by way of reduction to the minimum terms I impose in this case. Anthony Stewart, I turn first to you as you were aged 18 years at the time of the murder. I have found that the murder of Anthony Littler was motivated principally by robbery. It was therefore a murder done for gain. This means that the offence is one where the seriousness of the offence is described as particularly high by Schedule 21 and brings with it a starting point for the minimum term in your case of 30 years imprisonment. I have also found that hostility to homosexual men over and above their obvious vulnerability to robbery also played a part. That would also call for a starting point of 30 years, as well as being an aggravating factor. I find that the offence of murder was so aggravated. The offence is further aggravated by a significant degree of planning and by the fact that it was a group attack. At least one weapon was taken to the scene. As I am sentencing you for an offence which occurred 42 years ago, I do not treat your convictions, all of which are of some age, as aggravating factors. I do not find that you sought to interfere with the witnesses in this case. The offence is mitigated by the following. You had an intention to cause serious bodily injury rather than to kill, although it has to be observed that a blow to the head with a weapon carried a significant risk of death. You were only 18 years of age and had clearly come from a violent and troubled background. The character references show that you have led a largely hard-working and productive life since the commission of this offence. You have been in continuous employment, brought up 2 sons, largely alone, and have been a loving and caring husband to your wife who has suffered ill health. I will take these factors into account, but it must also be said that you have had the opportunity to live a good life, an opportunity you took from Mr. Littler. Had the murder occurred in more recent times and I was sentencing you solely pursuant to Schedule 21, the minimum term I would have imposed would have been one of 28 years. Michael Stewart, you were only just 15 years of age at the time of the murder, having turned that age some 3 weeks before. All of the evidence from your child points to you being the more aggressive of the two of you, even at that age, but your youth makes a material difference. As the motive for the attack was robbery, paragraph 5A of Schedule 21 provides a starting point of 20 years in your case for the minimum term. That said, if you had been 14 years of age, it would have been 15 years. I take a starting point of 16 years in your case. As with Anthony Stewart, hostility to homosexual men over and above their obvious vulnerability to robbery also played a part. I find that the offence of murder in your case was so aggravated. The same aggravating factors apply as for Anthony Stewart. I do not find your convictions nor your life post these events to be an aggravating factor. You do not, however, have the mitigation that Anthony Stewart does, that you have led a largely industrious life since the murder. I do not sentence you on the basis that you interfered with witnesses. Whilst your behaviour to both Daniel Stewart and AB has been threatening and intimidatory, I do not find that that was due to their involvement in this case, and again will not treat that as an aggravating factor to a murder that occurred 42 years ago when you were 15 years of age. In your case, the offence is mitigated by the fact that you had an intention to cause serious bodily injury rather than to kill, although it has to be observed, as I've already said, that a blow to the head with a weapon carried a significant risk of death. You too had a violent and troubled childhood. Had the murder occurred in more recent times and I was sentencing you solely pursuant to Schedule 21, the minimum term I would have imposed in your case would have been one of 15 years. As I have said, that is not an end to the matter. I must now ensure I pass no more serious sentence upon you than the Secretary of State would have done for this murder, which occurred before Schedule 21 was enacted. This is not a straightforward exercise, and to explain how I have reached the final sentences, it is necessary to set out the law which I have applied in more detail than would otherwise have been the case. In deciding what the Secretary of State would have done, I have regard to the decision of the Court of Appeal in the Crown against Sullivan and others, 2004 EWCA Crim 1762, which enjoins me to have regard to the guidance of Lord Bingham issued to judges in February 1997 on the length of the minimum term to be recommended to the Secretary of State following a conviction for murder, and to the transitional provisions set out in the Consolidated Practice Direction 2002, 3 All England Reports 412. In the case of Sullivan, the Court of Appeal said that in the majority of cases the ultimate sentence would not be materially different. This is because Schedule 21 only significantly affects the minimum term in the case of the first two starting points, where the seriousness of the offence is either exceptionally or particularly high, which the Court described as the minority of murders. If that description is still correct, this case falls within that minority. It means that the actual sentence I can impose today on each of you will be very substantially less than that which would have been imposed had the murder occurred more recently in time. The guidance of Lord Bingham spoke of 14 years as the appropriate period of the minimum term for what he called the average murder. It is clear that this was intended to apply to adult offenders. Lord Bingham identified a murder for gain as an aggravating factor that may warrant a more severe sentence, and youth and the absence of an intention to kill as mitigating factors which may warrant a reduction. Further guidance followed. The ultimate position was summarised by the Lord Chief Justice in the Consolidated Practice Direction, who said that there were a series of starting points. 1, a reduced starting point of 8 or 9 years for a case with reduced responsibility. 2, a normal starting point of 12 years. 3, a higher starting point of 15 to 16 years. 4, 20 years and for an especially grave case, examples of which within the practice direction are murder of a prison officer in the course of his duty, terrorism-related, or the sexual or sadistic murder of a very young child. And 5, 30 years or above for an extremely grave case. And finally, 6, a whole life term. I have referred in detail to this guidance because it is necessary to explain how it is that the sentences I actually impose are substantially lower than the application of Schedule 21 would now provide. In my view, this case firmly falls within the higher starting point of 16 years for the minimum term by reason of it being a murder for gain. I consider that your hostility to homosexual people, that this was a planned attack if you located a victim, and the taking of a weapon to the scene are aggravating factors which warrant an uplift to that starting point to one of 18 years' imprisonment. I must then reflect the mitigating factors. I sentenced both of you on the basis that you were secondary parties and neither of you had an intention to kill. Each of you was young. In your case, Anthony Stewart, your youth and other mitigation reduces the minimum term, in my view, to one of 15 years. In your case, Michael Stewart, you were only just 15 years of age. You were, on all of the evidence I've heard, the more aggressive of the two of you at that time, but your very young age requires a significant reduction to the minimum term. And in your case, I consider the appropriate period to be 10 years. Stand up, both of you. Anthony Stewart, for the murder of Anthony Littler, I sentence you to life imprisonment. You will serve a minimum term of 15 years, less the 491 days you have served on remand. By my calculation, that comes to a minimum term of 13 years and 239 days before you are eligible for release on parole. Whether you are released at that point will be a matter for the parole board. If you are released, you will remain on licence for the rest of your life. Michael Stewart, for the murder of Anthony Littler, I sentence you to detention at His Majesty's pleasure for life. You will serve a minimum term of 10 years, less the 491 days you have served on remand. By my calculation in your case, that means you must serve 8 years and 239 days before you are eligible for release on parole. Whether you are released at that point will be a matter for the parole board. If you are released, you will remain on licence for the rest of your life. Go down.